The Georgia Brokerage Relationships in Real Estate Transaction Act provides specific guidelines for brokers and their clients or customers in Georgia. This lesson will cover some basic principles about starting and ending a broker engagement. Naturally, the broker-client relationship begins at the time that a client makes a formal request for services. However, terminating the relationship can take several paths. The Act stipulates that the relationship ends when the broker completes performance of the engagement. In other words, the broker found a buyer for a seller or helped a tenant successfully sign a lease with a landlord. But what happens if there is no transaction to end the relationship? In that case, the relationship ends when one of three events happen. Whichever event happens earlier will terminate the engagement. These events are the date of expiration agreed upon by the parties during the engagement process or added to the engagement with an amendment arrives, or an authorized termination of the relationship is offered, or the engagement expires 1 year from the initiation date of the original engagement. As an example, assume the broker-customer relationship begins on May 10, 2018, when a seller requested service to locate a qualified buyer. If no buyer is found and the engagement did not stipulate an end date, the engagement would automatically expire on May 10, 2019. If the seller decided not to sell the house on December 13, 2018, the engagement would end on that date because the seller is authorized to bring the relationship to an end before the 1-year term. When the engagement agreement technically ends and the broker is relieved of the duty to perform, whether the engagement is withdrawn, expired, or otherwise ended, the broker still has a few obligations to former customers or clients. The broker still has a duty to account for all money and real property related to the engagement, and to keep confidential all information received during the course of the relationship, unless one of three events takes place. These events are the former client's speech or actions permit such disclosures, or the disclosure is required under other provisions of the Act or Georgia statutes, or the confidential information becomes public knowledge in any manner except that the broker breached the client trust. As an example, let's say that the seller, a politician in the process of getting a divorce, asked the broker not to mention his marital status to anyone because he was concerned about the public losing faith in his ability to serve. If the seller or the estranged wife revealed this bit of information to a reporter, the broker would be under no obligation to maintain silence about the issue. If a broker is faced with a decision to either breach a trust or give a customer false information, the broker must provide truthful information at all times. The Act protects the broker, and no cause of action shall prevail against the broker and their affiliated licensees for complying with this subsection of the Act.